Morning.
Morning.
Call to order the Waterfront LID assessment hearing, February 11, 2020. We'll be hearing case numbers CWF 171 first this morning at 10:25. Later today, we'll also be hearing 388, 357, 329, and 63 at various times on the calendar. Wanted to just, as we're moving through procedure, we're sort of being somewhat responsive to the development of the case as it goes, and did want to take an opportunity procedurally to address a matter with the city, and that is concerning the hearing examiner's decision is likely to try and respond to each of the objectors as they are raising their objections and noting those, depending on the scope of what presentation has been made. I'll be noting it in my decision in some manner or other. How the city is going to be responding to those could well weigh in how much time the city is going to need to present its case, and I know you've indicated that 2 days is what you're looking for. One tool that the city and or others may take advantage of in this is the opportunity to use declarations. So, for example, where the city may not be needing to present oral testimony to respond to each of the objectors, it may be helpful to at least have something in the record in the form of a declaration from the appraiser, and I leave that to discretion of the city how they want to manage that, so that there's something in the record, but perhaps not as much as you're intending to do. Right now, we're looking at, for the city, April 27, 28, 29, and 30. The city indicated they needed 2 days. The extra 2 days are for cross-examination of the city's witness.
Thank you.
Any questions?
April 27.
27, 28, 29, and 30. Any questions?
No, thank you.
Okay. All right, with that, let's turn to our objector for case number 171. Please state your name for the record.
My name is William Patton, and with me is my wife, Joni Ostergaard. We are both owners of a condominium within the local improvement district.
I can't hear him. Is there a speaker?
There is not a speaker, no.
So I'm talking to him, but maybe I should sit further away. No, it was better.
Yeah, don't sit too far away. The microphone serves a purpose in that it actually records the hearing,
Okay.
And so that's the actual recording
I'll try to speak
for the
louder
matter.
for you.
And let me swear you in. Do you swear or affirm the testimony you will provide in today's hearing will be the truth?
Yes, I do.
Thank you. Please proceed.
Okay, thank you. I just, following up on your introduction about the scheduling, wanted to make sure that we reserve our right to cross-examine the city's appraiser as a witness, not just through declaration, but presumably he or she will appear.
My assumption at this time is that they will be there and that there will be a determination made at that time who's there to do the cross-examining. We'll see how much time we need for that. I know that we have counsel and some objectors who want to do cross-examining. Some others are also in the process now of arranging for depositions. I'm not part of that, so I don't know how that's going.
Okay.
But there's no need to put your finger on it now, is essentially. You know the dates. Whoever shows up that day is how we'll proceed with that.
All right, thank you. So first of all, I wanted to provide you with a copy, I see you don't have one, of our written submission.
If this is the same item that you have in your objection, I do have a copy of it already
Okay,
for the
it's
file.
the same
Okay.
document,
Yeah,
but
we
there's
won't
another-
we won't
you have a
enter in.
copy.
I have
we
a
won't
copy
enter
already.
a new exhibit then.
Thank you.
Thank you.
So today, I don't want to read our 13-page brief, essentially, to the city about why this local improvement district is really illegitimate, and in addition, there are details which are mistaken and wrong in applying their whatever methodology they seem to have to our particular unit, but go through the major points of the document and provide you with some supplemental exhibits which will explain part of our argument here. And First of all, I wanted to comment on a statement you made on February 4th at the hearing within the City Council chambers, that you were making a recommendation to the City Council, but you were not really at liberty to challenge the ordinance itself setting up the local improvement district. And I wanted to provide you with just an excerpt from Washington Law Review article by Troutman. And that's
We'll enter that as Exhibit 1.
well, our submission has 9 exhibits, so I'm not sure how you want to keep track of those exhibits.
We're entering them, each item as it comes in gets a new exhibit number. This is identified as Exhibit 1.
Okay.
Thank you.
So, in Troutman's article, I didn't reproduce the whole article. I can for you if you wish. But it points out that the point of making an objection to whether a local improvement district is a special benefit or a general benefit, the appropriate time to do that is at the point of objection to the assessments. So there's clearly the authority to object globally to the establishment of an LID in the first place, because it really is set up for the purpose of a public benefit and not for private gain or a special benefit to any of the properties within the LID. So our contention is that at this point it is proper to make objections to the whole establishment of an LID because it's really set up for the purpose of public benefit and not private benefit. Okay. Secondly, in terms of looking at the first reason why we object to the LID formation is that the purpose really is for a public benefit, not a private benefit at all. And second exhibit I'd like to present is an excerpt from the Local Road and Improvement Districts Manual.
That'll be marked as Exhibit 2.
And this is a citation from a case, but it's included in the manual because it should be referenced by appraisers who are doing an appraiser in the state of Washington. And the case is Rogers versus the city of Seattle, where a local business is objected to an improvement district, really a business improvement area, because they felt it was in the public benefit. And the court stated the basic principle that a local improvement is a public improvement, which, although it may incidentally benefit the public at large, is made primarily for the accommodation and convenience of the inhabitants of a particular locality, and which is of such a nature as to confer a special benefit upon the real property adjoining or near the improvement. On the other hand, if its primary purpose and effect are to benefit the public, it is not a local improvement, although it may incidentally benefit property in a particular locality. So the basic juxtaposition of a public versus a private is what is the basic purpose? And the purpose of this LID is pretty clear from the city's own documents. That is, it is to establish a park for all. There's nothing in the city documents setting up the LID, either before it was established or as it was established, that the basic purpose is for the benefit of the properties located within the local improvement district. But rather, the basic purpose is to form a park and create a park for the benefit of all, a phrase continually cited by the mayor and the council and the director of the office of the Waterfront. There was nothing, indeed, in the city's formation documents that talks about the primary purpose being to benefit the properties within a certain area of the city. That is, the purpose of this park, the city itself has said over and over again, is to create a destination park, not only for all the residents of the city of Seattle, but all the people who may come here from around the country or around the world to enjoy. And only incidentally does it benefit the property in the area. And in fact, in our submission, we show an article from the AAA Association quoting Marshall Foster as saying that the objective, the vision of Seattle in setting up this proposed park is to provide a destination for all, for everybody to come. Not the purpose is never said for the purpose of to benefit the property owners within this circumscribed district. In fact, the very title of a local improvement district shows that the mistaken labeling and action to form a local improvement district that is local. It's supposed to be a local improvement, but as the city has said over and over again, it is a park that is meant for everyone, or for all, and beyond everyone in the city, everyone who might come or want to come to Seattle. In fact, it's compared by the assessor in the assessment or the appraisal, or as ABS called it, evaluation. The comparisons are with other parks that are around the country that are destination parks. They're not local parks at all. And I should stop here and I assume you have seen what property we own. It's a condominium on the 12th floor of the Escala condominium at 1924th Avenue, quite a distance from the main part of the park along the waterfront. I have another exhibit I'd like to enter, which is printouts from the city's website and a photograph I took myself of the Triangle Park, which is located at 8th and Western.
We marked as Exhibit 3.
So the city describes this park and the description of it, the history of it, and shows the schematics in a color format for how it should look, and then the photograph shows how it looks today upon finishing. It is as it says, a triangle park in a small piece of property that used to be the Enterprise Rental Office. And part of it was funded by the city getting money from vacating an alley for the benefit of the 9th and Lenora development, which you can see behind there. And so closed the alley across that triangle and created a small park. The total cost appeared to be about $2.5 billion. None of that money was from a local improvement district, although this park is an ideal example of what might be a local improvement, appropriate for a local improvement district. That is, it's a small piece of property. It's sitting there as kind of a pocket park benefiting the surrounding buildings and the Amazon buildings that are throughout this area and maybe 1 or 2 blocks away. But it certainly isn't designed as a park that anyone would come to Seattle to see. It is a park that visitors might enjoy walking by, or sitting on the bench and looking up the street at the Amazon spheres, but it's certainly not a destination park, and no one could possibly describe this as a park for all. But like all other city parks in the past, it has been funded with public money, not with a local improvement district. So this is the type of park that, pursuant to the court's decision in the Rogers case and cited in the manual, would be potentially appropriate for a, quote, local improvement district, but not a waterfront park that is so expansive and which the city itself has said the goal of which is to create a destination for visitors from outside Seattle. So in contrast to the proposed waterfront park, this could have been an example of where the city could have utilized properly a local improvement district. But the waterfront park is quite the opposite and is inappropriate for the use of a local improvement district. I wanted to briefly touch on the second argument we made, which is really a direct challenge to the legitimacy of the ordinance setting up the local improvement district. And in that regard, I wanted to give you another excerpt from, this time from a case of Hazard versus Edgewood.
Marked as Exhibit 4.
And in the Edgewood case, the court pointed out that the process for a hearing examiner to make recommendations to a city, and then what the subject matter of those objections could be, pointing out the fact that in making an objection to an ordinance, it is perfectly acceptable for the objector to make arguments about the underlying validity of the ordinance, not just the fact that it's inappropriate to be a local improvement district, but that it may have been enacted under circumstances which show it was arbitrary and capricious or otherwise unlawful. So not only is it appropriate for us to make this argument here, which you indicated on the 4th may not be appropriate to challenge the underlying ordinance, but it is appropriate for us to do that, and as well to preserve our rights upon appeal to a court after the city council decides what to do with your recommendation. And in this respect, the city really engaged in a quid pro quo subterfuge in enacting this ordinance. That is, it essentially accepted the offer of a bribe from the Friends of the Waterfront or people in that association, who said, as the city recited in what we attached as Exhibit 2 to our submission, that is a resolution setting up the idea of a waterfront park and how to fund it, that there was a group of what they called philanthropy that would offer to fund up to $110 million of the park, but only if the city agreed to establish a local improvement district to fund a great portion of that expense. So essentially, the city council, in accepting that offer, abdicated their legislative responsibility, because the council, instead of saying, we will gladly accept a philanthropy gift in support of a city park, instead said, and the city would therefore thereafter say, we will figure out how to fund the rest of that obligation to build the park. The city instead agreed with the philanthropists that they would agree to a particular form of financing. And that particular form of financing was to create a local improvement district. That is an agreement not to have all the citizens of Seattle pay for a park that is labeled as a park for all, but agree to, in exchange for an offer of a gift, to instead subject only certain properties to the payment for that other portion of the park. In addition to a violation of Washington state law and the Constitution, it is also likely a violation of federal law, because it's like a civil rights violation. That is, you've got one group of people urging a government agency to act in the detriment of a particular subset of other people. So we also allege that this is a violation of law, of federal law, 42 U.S.C. 1983, the Civil Rights Statute. Perhaps an odd application of the Civil Rights Statute, but it's the same principle. That is, you can't use a government agency as a means to attack another group of people. And essentially, what, beyond all the formality of what the city has said in its resolutions, is it appears that the motivation behind that is say, okay, hey, you know, we'll try and fund a waterfront park as long as you stick it to the people who are going to benefit from the new waterfront exposure of view, which really is not the benefit caused by a potential park, but the benefit caused by the removal of the viaduct. That's the main benefit that property owners near the waterfront have experienced, and it may be seen as an undeserved benefit that they happen to have property near what used to be a view of a roadway with lots of noise and dirt, and now there isn't a roadway there. But that's not the cause to make those property owners pay for a park that's really for the benefit of all, when the real benefit just occurred as a matter of course from the removal of the viaduct. Of course, you could see that the viaduct may have been used like the way in which the Highline Park in New York City was created. It was created partially with a huge donation of residents and other philanthropy sources to make what used to be an eyesore of an elevated train track in New York into a beautiful park, which has undoubtedly made the surrounding real estate more valuable. But the purpose of the park, which is not supported by an LID in New York, was to create a viewpoint, an elevated viewpoint with beautiful walkways and plantings for the benefit of everybody in the city. In fact, the Highline has become one of the three major tourist attractions of New York City. And the similar thing could have been done with the viaduct to make it a beautiful elevated walkway, except for its seismic liability, which is why it was torn down. But the fact that it was torn down and created financial benefits for immediately surrounding properties may stick in the craw of certain people, but it's not a reason to use the city of Seattle City Council and mayor to extract money from a small group of properties instead of the whole city as it should have been done. Now, the deficiencies in the attempt to make an evaluation or an appraisal of the value of the proposed park to various properties in the, quote, local improvement district boundaries, those difficulties really arise from the basic problem of the fact and incorrectness of the fact that this is labeled as a, quote, local improvement as opposed to a major public improvement, which it is. So trying to fit what is really described by the city itself as a destination park into the rubric and the requirements of a local improvement district really is difficult to accomplish and we believe impossible to accomplish because it goes against the basic and fundamental purpose of the proposed park in the first place. And part of the problem here is that the rush to create an assessment or evaluation of the properties within the LID or the local improvement district really creates major problems for an appraiser trying to make an appraiser when the details of the appraisal really don't fit the normal local improvement district structure. As in most local improvement districts, either for creation of a sewer line adjacent to houses that were previously on septic systems, or a roadway which wasn't paved or correctly or made in the first place, it's relatively straightforward to make an appraisal of the special benefit to the abutting property owners by looking at what the improvement cost and how much that increased the value of the adjoining properties. And if you're moving from a septic system to a sewer system, it's pretty easy to see that increases the value of a house which abuts the new sewer system, or likewise a major road improvement that allows the people that adjoin the properties that adjoin the road to use it where they couldn't before, even though a road can be used by anybody driving along. So there are ancillary benefits to the public at large, but the basic improvement is done for the adjoining property. And in those circumstances, you can make the assessment and make the appraisal of the special benefit involved, because you will have the cost of the improvements right there. They're easily determined, and they're easily determined as to which property it affects in how much. In fact, the Edgewood case that handed you, the fundamental problem in that local improvement district was not the fact that they created a local improvement district for a new sewer line, but that they charged the property owners for more than the benefit due to those properties, because the city wanted to make the sewer line larger than it was necessary for serving the adjoining properties, because they wanted to have enough capacity in the sewer line to serve later comers to the sewer line. But the city attempted to charge those adjoining property owners for the whole cost, not just the special benefits to those particular properties. And unlike that kind of circumstance where you can separate what's a special benefit to the adjoining property owner versus what are you doing to expand the sewer system for general future public benefit, with a park like this, a very expansive park that's really meant for the benefit of the entire city, it's really difficult for an appraiser to come in and figure out, well, what is the special benefit to the individual property owners, because those special benefits, if there are any, are only really ancillary to the main purpose of the park. And to try and do it before even the plans are finished for the park, it makes it even more difficult to fit that that round problem into a square peg, or a square peg into a round hole. And one of the first problems, the ABS evaluation problem it has in trying to do this is that it doesn't take into account what the main feature of the development of the waterfront park is. That is the removal of the viaduct. Without the removal of the viaduct, most of the proposed enhancements or the pieces of the park wouldn't occur because the viaduct was sitting right there in front of the viewscape or of the central waterfront. But the ABS appraisal really makes no effort to identify the specific costs and and particularly the benefits to the surrounding properties of the properties within this supposed local improvement district of the removal of the viaduct. And the removal of the viaduct is really the major benefit to all those properties. But it doesn't come as a consequence of the city's proposed waterfront park. It comes as a consequence of the state removing the viaduct and exchanging it for a tunnel through downtown Seattle. But even though I can say, it's just obvious, but the appraiser makes no effort to say, okay, what was the value of the property, each of the properties within the local improvement district before the removal of the viaduct? What is the value after the removal of the viaduct? And only after you make that specific economic calculation can you then make the calculation, which they attempt to do by just saying, well, we're going to ignore the viaduct and say that we're not counting the viaduct, but we're saying that the park improves the value of the property within the local improvement district. But you can't do that without first figuring out whether any increased value you think the appraiser thinks comes from the value of the park, whether that's really smothered by the effect of the removal of the viaduct. And that's really what's causing the increase, if there is any, in these property values. Secondly, and beyond just ignoring the economic consequences of the removal of the viaduct, the appraiser really fails to separate out what is a general benefit from a special benefit. That is, there are certainly general benefits to a major destination park. Even if you try to shove it into the construct of a local improvement district, there are general benefits to a park, especially a park of that magnitude. But the appraiser makes no effort to figure out what that is, because you can only figure out the special benefit once you subtract the general benefit. And in our submission, we provided a letter from 2018 from Anthony Gibbons, which makes that point, but he has since written another letter dated January 30th after the date of our submission, which emphasizes that point somewhat more. That is, not only did the ABS valuation fail to separate out the general benefit from the special benefit, but it also ignores the economic consequences to any of those properties from the removal of the viaduct. And as a further exhibit, I'd like to give you that letter.
This one will be marked Exhibit 4. The item previously marked Exhibit 4, I see it's just a case, and I'll take that as a courtesy copy for my records. It doesn't need to be entered as an exhibit.
It's already in that case.
No, typically I don't enter code or case law as an exhibit.
Oh.
It's not a fact item, it's
No,
part of
it
the law.
isn't.
So I wasn't sure what document you were handing forward to me
So
when
this
it came
one-
forward. But the resolve January 30th, 2020 item will be marked Exhibit 4.
So as in Mr. Gibbons' original letter that we submitted, he describes the failure because the ABS was attempting to make a preliminary evaluation as long ago as 2018, and they really haven't changed the direction of what they did. In their final evaluation, the report was dated November 18th, 2019, but the appraisal date is October 1st, 2019. And so the same principles that Mr. Gibbons recited in the 2018 letter attached to our submission is now again repeated because ABS didn't change its approach of failing to compare the before and after the elimination of the viaduct, and also failing to make a basic calculation, as you'll see on page 3 of Exhibit 4. That is the appraisal, which we quoted in our paper to you. The appraisal makes no attempt to assess general benefit and does not offset the apparent measure of special benefits with general benefits. And therefore, the appraisal ignores the basic equation, total benefit minus general benefit equals the special benefit. In fact, there really is no calculation in the ABS evaluation study of any total benefit. That is, the figure that they come up with, where it's impossible to determine from their statements, reports, as there is no methodology described. It is on page 8 of the transmittal letter, which is attached to as an exhibit to our submission. There is a calculation of total estimated special benefit of $447,908,000, but there is no calculation of a total benefit, much less a general benefit, which should be subtracted from that total benefit. Do you have that?
No, you didn't give me guidance to where that's at. You just referenced.
So-
I assume it's in the packet somewhere,
It
which
is.
you indicated, but where that is, you'd have to give me some guidance to get there. Which exhibit
It
is
is
it in?
Exhibit 6
Okay.
in our submittal.
Exhibit 6 to the objection.
Yes, and it's the cover page in the transmittal letter and summary from the ABS valuation. That, so,
Which page?
it is on page 8 at the bottom, where you see all those dollar numbers.
Yes. Okay.
It's next to the last page
Right.
at the bottom. There's the calculation of the total estimated special benefit, $447,908,000. But nowhere is there a calculation of the total benefit or the general benefit, which would be subtracted from the total benefit to get a derived special benefit number. The reason we attached this transmittal letter to our submission is because the report comes in various pieces, and it's hard to keep track of, at least it was hard for me, to keep track of the totality of those submissions. That is, this transmittal letter came separately from the ABS evaluation itself, and within the ABS evaluation itself, there's a whole list of properties individually described in spreadsheets, which wasn't actually available on the transmittal date of November 18th, but only came later. And in fact, the whole series was not available on the website until January. But there are these pieces of it that are important to keep coordinated so that you can understand not only what they attempted to say, but the dates at which they attempted to say it. And now there's an appendix to an addendum to the study, which is essentially descriptive of the various pieces of the proposed park, but it's not necessarily part of their evaluation. So in line with Mr. Gibbons' first letter and second letter, the appraisers have failed to take account of the tremendous effect of the elimination of the viaduct versus the value of it, if any, of the proposed park to individual properties, and have failed to account, as Mr. Gibbons points out, the requirement to really identify and calculate the total benefits of a proposed improvement and subtract from that the general benefits in order to get the totality of any special benefits that might be allocated to the properties. And that, again, is the fundamental problem of the ABS valuation as they attempted to go through and make individual valuations or appraisals of property, in that the point of this park is to create a park for all and to try and figure out what, if anything, that has to do with the value of a particular piece of property is a huge and really impossible undertaking for an appraiser, which is faced with the problem of trying to figure out an appraisal for something that isn't even designed yet, much less built, and for such a large geographic area where there are 6,238 properties. So essentially the appraiser admits that they gave up and are really doing a mass allocation, which is really upside down from what an appraisal for a local improvement district should be. That is, it should be an individual appraisal of the before and after benefit of the property, as opposed to just trying to say there's some percentage allocation that's kind of right for individual properties. You know, one can understand the difficulty that someone is faced with if the city asks an appraiser to go appraise the increase in value of 6,238 properties, but that's what the city asks the appraiser to do, and inevitably the appraiser failed to do that. And if you look again at Exhibit 6 of our submittal on page 3,
This is Exhibit 6 of your objection.
yes. This is what we've called the cover sheet and the transmittal letter of the ABS evaluation. it notes that there are 6,238 individual tax parcels in the local improvement district area, and of which 5,187 tax parcels are in 49 plus or minus condo projects, of which ours is one. So the appraiser attempted to make some special benefit determination derived from enhanced relative location provided by LID improvements and other factors, but really nowhere does the appraiser set out exactly what the methodology is for figuring out that total special benefit of $447 million, or how any particular piece of property is appraised. In fact, on the next, on page 7, there's a chart showing that the appraiser essentially used percentages to figure out what might be the increase in value, as opposed to looking at any individual piece of property as is required in an appraisal of an LID, and figuring out what the specific special benefit to that specific piece of property is. It's the ABS explanation on page 2 of that Exhibit 6 to our original objection says that there is supporting documentation retained in the appraiser's files. But those files were not available at least until February 5th, when they appeared on the Waterfront LID website. And I looked for any fundamental backup data that would apply to our particular condominium unit in the Escala condominiums. And there was a folder labeled Escala in those documents. That's the only reference I could find to Escala properties in the backup data provided by ABS. And I reproduce it for you. It is somewhat awkward to look at. It's a big spreadsheet. It won't print on one page, so you have to unfurl it like this.
It's marked as Exhibit 5.
And I certainly need my glasses to read it even in this expanded form. But you see that there are, the addresses are all 19 24th Avenue and various condominium units described below, and the apparently, it looks as if this is information from realtors and listing agreements, maybe from the MLS system, trying to figure out what the sold prices were of various condominium units. As you can see, these are all on all 3 pages. They are limited to units in the Escala development, which is 19 24th Avenue. But the peculiar part about this data is that if you look at the top, and it's chronological in the latest first at the top, the latest sale noted here is August 31st of 2016. Whatever relevance this data has to market values as of October 1st, 2019, I failed to find any. And in fact, even within the data that's provided by ABS in this file folder labeled Escala, the latest sale is stated as August 31st, 2016. Joni and I purchased our condominium unit on June 14th, 2016, and it is not listed here. So not only does the date end in August of 2016, it doesn't even include condominium unit, which is 1208, which was officially recorded with the county on June 14th, 2016. So not only is this totally out of date, but it's inaccurate, and if it purports to contain all the sales within the condominium development. In fact, if you look backwards, you can see that way over on kind of fourth, the third page, scotch taped together, starting in about (2012), all of the units are owned by Virginia, 4th and Virginia Owners LLC. This is because the condo was built in 2009, and right at the wrong time when during the recession, the Great Recession of 2007, 2008, and most of those units remained unsold for a long time. So whatever data ABS intended to rely on, the data for the Escala condominium building at any rate is totally useless for making any determination about what a value change would mean to any of the condominium units in that building for a project that's not even designed yet, much less built. And in looking at just the kind of percentage methodology that appears to be the methodology for ABS in making kind of gross allocations of the cost that the city told them to allocate, ABS makes no real attempt to differentiate between different elements of this park. The park is designed with a multitude of elements, and some of which are really artificial, like the Pike Street extensions, really artificial with the design to incorporate within the, quote, local improvement district, buildings that are far away from the waterfront. And there's no attempt to say, well, I suppose, from what element is the benefit derived, and how far away from that element does the benefit accrue to any property nearby, or even if it's not adjoining, and most of the properties are not adjoining to any of these improvements, as ours is not. That is, we provided a photograph in the original objection that we submitted of the closest proposed part of the park development, which is the Pine Street development, showing that you can't even see any of the proposed improvements from our condo building. In fact, even condos that have a water view in our building can't see any of the waterfront improvements either. But there's no attempt to differentiate between, okay, this building is, 2 blocks away from street planters, which is essentially what the Pike Street improvements are, or this building is right next to the waterfront overlook. I mean, those are quite different in terms of the expected increase, if there is any, in the value of the properties from a park development. But there's no attempt to make that kind of individual assessment other than kind of a gross percentage change one way or the other, depending on where the property may be located. And I may take a little more than 5 minutes that are left, if that's okay with you.
Let's see where we're at when we
Okay,
get there.
so if you look at point 9 and the reasons that we object to the assessment, it's basically that the ABS valuation assumes that the property values are all increasing in Seattle. And that's demonstrated on Exhibit 6, that's the ABS transmittal letter. On page 7,
Again, just for the record, we're referring to Exhibit 6 to the objection.
yes, that's correct. And at the bottom of page 7, it says, although it is recognized that this new supply of condos, et cetera, will be competing with existing space, the currently strong demand will be enhanced by the subject LID project and is expected to shorten the absorption period. So throughout the ABS evaluation, there is the assumption that property is all increasing in value in Seattle, and the park is actually just gonna add to that increase. First of all, as we say in a few minutes in section 10 of our objection, we pointed out that's inaccurate. But even if it were inaccurate, the ABS valuation fails to take account of what the courts have talked about in terms of ignoring overall market trends and trying to distinguish what any particular improvement may mean for a particular piece of property when all properties are increasing in value. That is, how do you differentiate that? And that was the circumstance in the Bellevue Square case where the Supreme Court said you can't, there's no evidence that shows any differentiation between a general property increase and any increase that might have been caused by the Fourth Avenue improvements in Bellevue. So the attempt to assess a particular property when all properties are increasing without making a very clear distinction about whether that's just due to general increase of property values or really has anything to do with the improvement, there's no discussion of that problem, and really appraisers ought to take account of what courts have said about the importance of specifically looking at economic conditions when trying to take account of those valuations. Now, in moving on to section 10 and the particular issues with the valuation of our particular property, the fundamental mistake, which really disqualifies all of the ABS valuations for the entire, quote, local improvement district, is the fact that the ABS valuation states that the date of the valuation is October 1st, 2019. But when you look at what they stated for our own particular property, they have failed, as they do generally, to acknowledge the fact that the assessed values by the assessor and just generally market values for properties have decreased, not increased, but decreased in 2019. And even if they had acknowledged that, they would then have to specifically figure out whether any benefit of the proposed park made any difference or perhaps caused the decrease in value in property values in central Seattle over the last year. But they don't even acknowledge that. That is essentially what they've done is rely on 2018 data. And trying to figure out how ABS came up with a particular valuation of our unit, it was a struggle because there's no description of how they did that. So to try and look at that, I looked at the specific spreadsheets that finally came out, and actually the spreadsheets are dated December 4th, 2019, not October 1st, 2019. Staring at these numbers to figure out how in the world they came up with a value. And I'm used to looking at these spreadsheets in their form that gets printed off a computer, but I went to FedEx and had this blown up, so it's a little easier for you to see.
It's being marked as Exhibit 6. How are we doing on time, Mr. Patton?
I have about 10 minutes more. Is that okay?
Is there a way you can summarize?
Well, it's summarized in our submission, but so I'll try and do it within 5 to 10 minutes. How's that? So if you look at ours is the second line across. Ostergaard, Joni H. and William, not enough room on the assessor's web to have my full name. So the special benefit is noted as $9,341. And look at the total assessment because they figured that would be 40% of the value, $3,660, and they show a market value with the without the LID, and then with the LID. And those are very specific numbers. $1,245,425 without the LID, $1,254,766 with the LID. And I kind of stared at this for a long time trying to figure out where that came from. It actually comes from a derived number from the assessor's office, which is an exhibit to our original submission. It's Exhibit 8. And you can see the 4 cards that we've received since we own the property of the assessor's valuation. And in the 2018 assessment, the buildings are valued at $1,254,000. That's in the lower right card. In the middle line for buildings, the new value is $1,254,000. Well, that's pretty close to $1,254,766 is market value without. So I said, okay, well, they must have used that number to derive whatever these silly and specific numbers are. So I try to figure out what percentage of $1,254,000 was the special benefit of $9,341, and if you divide 9,341 by 1,254,000, you get 0.74%. And the way the ABS apparently fiddled with the numbers in order to look like they were doing something precise was you take $9,341 and subtract it, or you then figure out what 70.75%, if you divide that into 9,341, would result in, and it results into $1,245. $1,245,425. So they plunked that as the market value without, and then just added what they kept, the $9,341 to that number to get the supposed aftermarket value of $1,254,766. That math is described in Exhibit 9 to our original submission. So this is really a derived number trying to look like it's precise, and it's derived from trying to take from looking at the King County Assessor's values, but the values for 2018, whereas the purported date of the valuation is October 1st, 2019. And on that date, there were certainly revised assessment numbers from the assessor, because we got one which was mailed on August 1st. And it shows in the parallel column for buildings a decrease to $1,049,800. So ABS has just taken, it said it used electronic data from the assessor's office, but they used it for the wrong year. And if they had used the correct number and used this artificial division and assumption of exact numbers by dividing by 0.74% and then adding that to get 0.75% number, you would get obviously a lower, quote, special benefit and a lower assessment, taking 40% of that. And that math is also done specifically on Exhibit 9 to our submission. So you see that. And if you did that, the assessment would not be $365,089, but $3,043.88, even using the artificial allocation construct which ABS used. And here's an exhibit showing what you get on the website if you look at our assessment from the assessors. I gave you two.
Marked as Exhibit 7. All right, so was that?
Yeah, so 2 more minutes. The assessors claims that they're looking at a limitation on the amount to charge within the local improvement district of $175,500,000. But the city and the total cost, as stated by the city in Exhibit C to its formation ordinance, is $346 million. So if you look at the amount that the LID is asked to pay for this park, it's more than half of the park, even though it's a park that's built for the general public benefit, and in fact the national benefit. But the city really engages in a subterfuge further in its literature talking about the park when it uses a pie chart showing that the cost of the park is excess of $346 million. For example, this is a July 2018 brochure about it, showing a pie chart where the local improvement district then of $200 million is a small portion of the cost.
We'll take that and mark it as Exhibit 8, and if we can wrap up in 1 minute, that'd be great.
Showing, well, you shouldn't be bothered by this because you LID people are paying only a small portion of the park, when actually this is quite a misleading pie chart, because it doesn't state the city council's statement of what the cost of the park is, which is $346 million. And in this brochure, as you'll note, once again, it demonstrates that the city is not looking at this as an improvement to benefit local property, because there's nothing in this brochure that talks about local property. Instead, on the back of this brochure, it says, as is stated over and over again, Seattle's waterfront for all. Therefore, the LID is, in terms of the enactment of it, is incorrect as an approach to a local improvement district. It's not a local improvement, it's an improvement for all. It's a destination park. And within the attempt to make an appraisal, the appraisers have used outdated data, if any data. They've used an allocation methodology instead of an appraisal methodology. They've used the wrong year for appraising the value of our particular property and done math which looks like it's precise, but it's not. So we
Thank you, Mr.
urge,
Patton.
we urge you to recommend to the council that they abandon this attempt to invalidly identify a, quote, local improvement district.
Thank you, Mr. Patton. I have a question for you. Looks like you gave me the same case twice.
I did.
Hassett. I don't know if you intended to give me a different case instead of Hassett.
Oh, no, I probably gave you my copy.
Okay, that's fine. You had made reference to a Bellevue case as well, and Bellevue Square case, and I didn't know if you intended to.
I didn't give you a
This is
piece.
the only one?
Yeah.
Okay. I understood that you cited this concerned about the scope of review by the hearing examiner as stated in the February 4 opening of the
Mhm.
hearing. Just for the record, I was quoting directly from your Exhibit 2 Local and Road Improvement Districts Manual, so they're the ones that were setting what can be reviewed and not. I'm looking to the case that you've identified. I understand there is a question as to the validity of the LID and certainly its scope between general and special. And I don't think that issue is completely off the table for me if that was intended as if that came across as my comments. Question though, I want to make sure that I'm understanding the scope of what you are arguing my review is within based on the case. The case certainly goes at the questioning the decision of the council, but it does seem to indicate clearly that the court is limited to nullification or modification of only those parcel assessments before it. Is there something more in here that you're arguing that goes at to the legitimacy of the ordinance itself that I can apply, or
Well, yes.
and where is that?
Well, it's in the excerpt from the Hazlitt case. That is, the application is, we cited there's a case challenging this ordinance basically on the Open Publics Meetings Act deficiencies. And that challenge presumably would undo the whole ordinance for everybody. Now, as an objection, the courts may, as an objector, the courts may decide that the entire local improvement district ordinance should be nullified because of its deficiencies, but the result would possibly only pertain to our particular unit.
Okay.
But that doesn't mean that the court wouldn't consider, nor should you, doesn't mean that you shouldn't consider the invalidity of the ordinance itself. I mean, your recommendation to the city council may affect only ours because maybe we're the only people making that argument, but it doesn't mean that you can't consider those issues.
Understood. All right. Thank you.
Mr. Hearing Examiner, I have just a couple questions
Yes,
for Mr.
please.
Patton. Mr. Patton, you are not a certified real estate appraiser,
I am not.
and you have not received any formal training appraising real estate?
I have not.
Thank you very much.
Anything further on rebuttal? No. All right. Thank you. We will adjourn and continue the hearing. We re-adjourn at 1:15 for case number 388. Thank you. Afternoon. We continue the Waterfront LID assessment hearing. We're hearing now from case number 388. Please state your name and spell it for the record.
I'm here on behalf of the Cirrus Trust. My name is Prashant Bhatia. The first name is spelled Prashant, and the last name is B as in boy, Hatia.
Please proceed.
Okay. I'm here to appeal the lid assessment on tax parcel 253-883-0580. I submitted documents earlier prior to the hearing appeal deadline date, so I'm just going to read part of those documents and only part of it, my letter, in the interest of speed, and then I have some updated valuation information on new sales data since last week. It was recorded by the city. So I'm the owner of this via trust of the condominium stated above. I have lived in it since it was purchased in January 2009. And along with many of my neighbors, I have a strong objection to the entirety of this specific tax assessment. One of the reasons is that the funding is highly speculative and the delivery of these purported special benefits are highly speculative. This is in reference to my letter. The city has stated that the waterfront lid projects will cost approximately $346.57 million, yet the lid assessments will be capped at $160 million. Therefore, at least an additional $186.57 million will be required to complete the remainder of the promised waterfront lid projects. While the city believes it will somehow attain these additional resources from, quote-unquote, city, state, and philanthropic funds, these funds have not been secured or allocated. In other words, given that over half of the funds for the waterfront lid projects are unsecured, the city's actual ability to complete the waterfront lid projects is highly uncertain. Furthermore, if there are any cost overruns, which are not uncommon with the city's projects, these will only increase the risk even further with regards to the completion of the waterfront lid projects. Given that there is such uncertainty around the full funding and completion of the waterfront lid projects, it's clear that the purported special benefits to the assessed property owners are highly speculative. Based on the funding facts, affected property owners have no reason to be confident that the city has a way to deliver its promised special benefits. Furthermore, if the city were to fail to find adequate funding to fully complete all of the waterfront lid projects on time and as currently designed and analyzed by its assessor, then it would have collected $160 million in tax assessments without delivering the projects as legally required to. This failure could open the city to legal action from disgruntled property owners, which is an outcome that should be avoided at all costs in the interest of the city, taxpayers, and property owners. Even if I were not an assessed property owner, I would be alarmed if the city were to take on such a large legal obligation without reasonable risk mitigation, i.e. securing all funding first. I believe that most city voters would far prefer that the City Council spend money on actual pressing needs to improve our city rather than fighting legal battles resulting from the city's foolhardy decision to take on massive lid commitments without a reasonable plan for delivering them. In summary, the city should not be permitted to assess property owners on a promise of delivering special benefits based on plans that are still highly speculative. Instead, the city should not take on the legal obligation to complete these waterfront lid projects without first securing all necessary funding. I also have issues with the valuation of the property, which I'll get to in a minute, but I'm going to go on to point 4, the lack of special benefit. My understanding of the legal definition of special benefits comes from the Washington Practice Instructions. Special benefits are those that add value to the remaining property as distinguished from those arriving incidentally and enjoyed by the public generally. Given this definition, it's worth considering that my building is physically remote from the central waterfront, both horizontally and vertically from the central waterfront, as we are more than 3 city blocks, 1,240 feet from my building lobby entry to the promenade on the west side of Alaskan Way. The building entrance is also 116 vertical feet above Alaskan Way. The waterfront is clearly not convenient for residents to take their dogs for a walk or go for a stroll. The value of my home from a location perspective comes from proximity to convenient shopping, services, and employment offices in the downtown core. Additional value for the west-facing condominiums in our building comes from the views of Elliott Bay, but clearly not from the proximity to the waterfront. The city has repeatedly touted relevant projects as a waterfront for all. The design goals were clearly not to create a local improvement for property owners with some proximity, i.e. special benefits, to the multi-year construction and resulting project. The waterfront and all the project includes, including the lid projects, are meant to create and enhance a regional, national, and international tourist destination. As outlined in the Anthony Gibbons letter, which I've attached, there's a general lack of clarity distinguishing general and special benefits and major discrepancies and flaws in the methodology used by the city's appraiser for this initiative. As an example, the estimated value lift applied by Valbridge is less than 4%, which is within the margin of error for any appraisal and thus by definition speculation. I've also provided a video and as well as screenshots showing Alaskan Way without lid improvements and with lid improvements. And there's no clear difference that would justify any increased value to my building or neighboring residential buildings. The post-lid view is essentially that of a wide waterfront boulevard with some grass medians. It has not been explained how this outcome will increase our property values and confer special benefits. In general, the lid improvements do not add anything significant to the central waterfront, which already will have a promenade, viewpoints, stairways, elevators, and landscaping, as well as connecting streets and bridges even without the lid. Therefore, there's no substantive case for a special benefit conferred on residents in my building. Next, my unit on the 18th floor has the bulk of its view on the east side of the building with a skyline view. I've attached a photo, which will be lost when the proposed 46-story tower directly east of this building across 2nd Avenue is built. The loss of the skyline view and the loss of most of my sunlight will certainly reduce the current market value of our home. Also note that the proposed tower will not have a lid assessment on the tower improvement, as it will not start construction until the fall of 2020 and will take 3 years to build. These types of omissions are patently unfair. Next, not only would the proposed lid projects, assuming the city can even find the funding to deliver them and deliver them on time, fail to deliver special benefits, some of these projects would damage my property values. For example, the proposed changes to Pike and Pine Streets between 1st and 2nd Avenues would restrict vehicular access to and from our parking garage, which is in the alley between 1st and 2nd Avenues and between Pike and Pine Streets. This $23.4 million of budgeted spending would also make it more difficult for my building to receive packages and services. In 2019, my building alone had 15,474 packages delivered and over 500 service vehicle calls. Similarly, 4 years of construction, limited to 4 only if the city quickly acquires the remaining funding and the projects are on time, both unlikely, will cause additional inconveniences to residents of my building and further depress values in the process. Next, the city's inability to maintain a safe and attractive atmosphere in my neighborhood does not indicate that there will be any increase in my property value due to the lid assessments, as the city will now have additional challenges to maintaining such an atmosphere. The city's inability to prevent frequent violent crimes near my building, as was reported nationally, 9 people were shot in a mass shooting just 1 block away just last month. This inability may extend to the new waterfront and adjacent areas. These large urban park areas are known to be difficult to police, e.g. Westlake Park, Freeway Park, and combined with the increasing news coverage of violence in various areas of downtown Seattle, the waterfront and lid projects may depress property values even further than they have been over the last several months, as residents and visitors alike continue to feel unsafe in downtown Seattle, even at our own courthouse. Similarly, I'm going to show a photo. This is a Sunday morning directly across the street from my building. There's just a tent set up there on a Sunday morning. Again, I don't understand how the city's going to maintain a safe atmosphere. Similarly, please see the recent photo attached to a homeless person's tent erected directly across the street from my building. Widespread media coverage and knowledge of the city's failings in this area, along with an actual unsafe atmosphere downtown, will further scare away potential buyers and devalue my property, especially as the lid improvements may exacerbate those challenges. In general, the city's determination to ram this lid through by taking so many shortcuts shows a surprising lack of understanding of property values in general versus special benefits by the city's appraiser, even after the city spent millions of dollars and several years having the studies prepared. I strongly object to the city's speculation that there will be any special benefits to my property and suggest that they may, in fact, depress property values for years to come. And then just jumping to the end of the letter. Overall, I do believe that even without the lid projects, many of the new waterfront projects have the potential to provide very attractive public spaces to domestic and international travelers, particularly during warmer weather and the longer days of summer. However, the proposed lid improvements will enhance a regional attraction, the Waterfront Park, that will benefit from its location next to the most popular tourist destination in Seattle and the 33rd most popular tourist destination in the world, Pike Place Market. The lid improvements will not confer special benefits specific to me or my immediate neighbors' properties. So that's my letter, and then I can just take us through quickly. There's some updated valuation information on a sale, including a sale that closed since the last hearing.
Note for the record that the objectors referenced several documents and some photos, like a tent. Those are all attachments to the original objection for the case number 388.
Okay, so let me know when I can start. Okay. Okay, so I'll just go to page 2. So the asserted market value, it's excessive and it's not supported by the evidence.
We're not using that one.
And I'll show, sorry?
Oh, no, I was just
Oh,
saying.
okay. I'll show the comparable sales in a minute, but they prove that the city's overestimated the value of the property by more than 30%. And even the special benefit percentage change for the 1521 Second Avenue building remains 2.7%, something I've disputed in other parts of the argument. And the overestimation of the market value by more than 30% means that there's an overassessment of more than 30%. I'm going to jump to in the first page after the appendix. It's our lid assessors data. So this is from the supplementary materials that were released recently after the last hearing. And this is the lid assessors data looking specifically at the O2 stat. Because our valuation in that building is, the floor plans and finishes are identical up to about 29 or so at least. And the only difference is the height and the view. And all of that is a city view with no view of the waterfront. So if you look at their methodology, well, if you look at their assessment and then you look at a simple floor rise methodology based using actual sales, so you can see 1002 was sold in June of 2019. And then the other sales data, he used listing prices because he didn't have sales data at the time he did this. But even if you look at the floor rise using his listing prices, the pre-lid value of 1802 should be about 1.66 million. His pre-lid valuation using his data is 1.9 million. So I don't understand this justification, and I don't think he's provided any for how he's getting there. If we go to the next page in that appendix, this is including the latest sales data of last week using the same floor rise methodology. So now we have actual selling prices not only for 1002, but for 2702 and 2902. One of the things you'll notice is that 2702 was sold in October. 2 floors higher was just sold a couple weeks ago, just recorded now. And it sold for the same price as 2702, which shows clearly that values seem to be declining, actually, as the lid advances and other issues occur. So if you use 2902 and 1002 as your benchmarks to calculate the floor rise, it's about a little over $30,000 or under 131. That would give a valuation, a pre-lid value of 1802 at 1.463889. That seems to be a much more reasonable methodology based on actual sales data in that building using the most recent data. And so even if I was in agreement with the 2.7%, that would give a post-lid valuation of 1.503414. So about $400,000 lower than the assessors. The next page is just a summary, so I think that it's already captured. Let's go to the, I think there's a 1521 Second Avenue building. That's just a picture of the building. It's on page 4, I think. This is a floor plan. So the right side that has the curve, that's all east-facing views into the city. and that's where the 46-tower story is going to start construction in the fall. So there's no view of the waterfront or lid improvements from there. Next page is just the comparable data we just reviewed. Next page is the excise tax affidavits. Next page, market value. Next page just discusses how the higher floors command higher values. You can probably skip through that. I think there is an error I need to correct of the proposed 15. Sorry, no, that is correct. So if you, at his special assessment percentage, I think it was 39.18%, that means the final assessment, even if we agreed to 2.7%, special benefits shouldn't be more than $15,485.90 if you use the recent sales data. Furthermore, there are no special benefits to this property. If we look at some of the lid improvements, the Promenade Park, it's a large roadway with landscaping that's quite far from the unit. Pier 58, that's an event space that's clearly a general benefit. The Overlook Walk, there are already several access points to the waterfront, and at best I'd say it would benefit the throngs of tourists visiting the market. Pioneer Square, that's really quite far from the unit, so I don't see how that would be any special benefit or even a general benefit to anyone in our area. And then the Alaskan Way lid improvements, those are quite far from the unit, and they're really minimal, of minimal benefit. I don't see how they would provide a special benefit either. And then finally, on the last page, just a continuation of that, there are no special benefits to this property. The city's poor park management has made parks more of a safety hazard than a nuisance. The Compton research from Texas A&M on certain types of parks, likely this one, it shows that there's a negative benefit to nearby properties if parks are not well managed. And then even if the park is better policed, there's this likelihood of negative behavior being pushed into areas just off park near this building. You know, we'd see more things, we're afraid, like this tent on the street or other types of negative behavior. The property value has decreased as this lid process has been advancing, and the unit has no significant view of the park area. I think that would be it for me.
Okay. Thank you. The PowerPoint will be admitted as Exhibit 1, and I don't know that I admitted all of the exhibits from the last case that we had today, 171. All exhibits submitted as part of 171 are admitted. Were you here for 357, case 357?
Yes.
All right.
Am I finished? Or?
That's up to you.
Oh, yes,
yes.
I'm done unless
Mhm.
anyone has questions for me.
No, thank you.
Thank you for your time.
Thank you. Ready for the next objector?
Good afternoon.
Afternoon. Please state your name and spell
My
it.
name is Dwayne Ord. I'm representing Linda Ann Campbell, case number CWF 0357. Do you need authorization from her?
It'd probably be good to introduce it to the record. Can you spell your last name?
Yeah, O-O-R-D. Yes. Dwayne is D-U-A-N-E. Oh, it's right there, yeah.
The representative form will be marked and admitted as Exhibit 1. And do you swear or affirm the testimony you provide in today's hearing will be the truth?
Yes.
Thank you. Please proceed.
Okay. Okay, well, this is the first time I've ever been at one of these guys. So bear with me. What I've done here, since I'm not a public speaker, I've written out what I want to get across. I know the other day when you, on the 4th at your hearing, I believe I remember hearing you say you only rule on law and precedents, if I recall right.
That's a reasonable interpretation of
Okay.
part of what
Just,
I said.
Yeah, in 2 or 3 words. Anyway, there is a couple clarifications I had as it relates to this notice of appeal hearing, that letter that we received. And that's probably half of my questioning. The notice of appeal hearing, CWF 0357, a scheduled hearing for Tuesday, February 11th, 2 to 3 p.m. to Linda Campbell, she received by U.S. mail. The appellant's, and it states, the appellant's failure to appear on time will result in forfeiture of the appeal. This statement conflicts with a statement in box in the bottom of the 2020 LID assessment roll hearing registration form provided me at the February 4th, 2020 LID hearing assessment hearing. The hearing registration form acknowledges the Office of the City Clerk has received written objection and has assigned the case number in the top corner of, which is CWF 0357 for property owners or representatives who intend to speak at the Waterfront LID assessment roll hearing. The hearing registration form acknowledges their intent to present written objection at the hearing. Persons who filed written objections may but are not required to speak at the hearing and present their written objection. Nowhere does the form state appellant's failure to appear on time will result in the forfeiture of the appeal. Maybe you can clarify that.
I'm not going to spend a lot of time clarifying things for you. This is your opportunity today
Okay.
to present your objection.
Okay, but it's on
I
record.
will highlight that
Okay.
there's no requirement for anybody to testify.
Right.
The notice, the second notice, which is not the official notice of the hearing, the official notice was issued in December for the hearing that was on February 4th.
Yeah.
As a result of the hearing on February 4th, there was a continuance to specific dates for individuals who expressed that they desired the opportunity to speak. If they chose not to, their objection's still in the record, it's still legitimate.
Okay.
If someone indicates that they want to speak, but they fail to show up, we're not just going to keep this going on for them forever. That's what that notice was saying.
Okay.
We're
Yeah,
not
I've been
here, we're
late.
not here open. You missed,
No.
if she
Okay.
missed today,
Okay.
then she simply, her objection would still be here, but the opportunity to orally object would not be recognized.
Okay, so we'll continue. I want to confirm Linda Campbell submitted a written objection and appeal along with attachments or evidence supporting her appeal to the City of Seattle clerk, City Clerk on February 3, 2020, which you should have in your documents. We now submit this question to the hearing examiner. How will Linda Ann Campbell personally receive a special benefit of $21,221 with the proposed cost assessment of her to her of $8,315 from the proposed park and street that the city wants to build? A little background. Linda was diagnosed with stage 4 neuroendocrine pancreatic cancer that metastasized her liver. She's on a prescribed oral chemotherapy regimen she takes daily. She acquired the condo on which the proposed special assessment, not for the city park or the street to be built, but to be close to her medical care providers in the hospital, the latter of which she's been admitted to on numerous occasions for infections or viruses contracted because of her poor immune system and its inability to fight them of treatment of the cancer itself. There are many factors that can be argued why the residents in the condominium carplex where her condo is located and why the proposed assessment is wrong and should not be upheld. I know you've heard many arguments at the February 4th LID assessment hearing, so I won't burden you with that. You've already heard a lot of stuff. You may or may not be aware the Seattle Transportation Department's inability to manage construction public projects on budget and on time. They always have excuses, but in the end, these costs result in higher amounts that the taxpayers must absorb, both directly and indirectly. I ask rhetorically, how does the City of Seattle propose to deal with delays and cost overruns not included in their original budget? One only has to drive the streets of downtown Seattle to experience how well SDOT manages potholes in the street. You are likely aware of the recent shootings and deaths that occurred in downtown Seattle. This was 5 blocks from subject condo. Earlier that day, there was another shooting in which the sheriff was involved, of a drug dealer. That was a block away. And months ago, there was a murder 3 blocks away in a parking lot after they came out of a nightclub. Double shooting, and they shot each other. Did the city's lid, or for that matter, the county assessor, take these into consideration in establishing the property's value and resulting assessment? Now, I know the county assessor isn't involved. He just does his own assessment for tax purposes. But whoever's in charge of the lid, is that been considered? And again, rhetorically, we believe the answer to that. We all know the answer to that. Lastly, I want to mention the appraisal that was performed to evaluate the properties identified in the lid assessment areas. Even commercial banks and credit unions, when making loans to people, are required by regulation to obtain written appraisal review by an appraiser possessing the proper credentials to assess the methodology and valuation conclusions the persons performing the appraisal arrived at. The present minimum appraisal review threshold for real estate that have loans of $400,000 above is the $400,000 threshold. The appraisal on this property is $1.2 million-ish, let's say. That's the assessment. We've provided you with appraisals and so forth I won't get into right now that have a lower value. While the city may have engaged Gibbons and Riley PLC to provide a letter of opinion of the Valbridge mass appraisal, within the first paragraph of that letter, it states this is not an appraisal review. I close by asking the examiner to do the right thing. Do not approve or recommend to the Seattle City Council the proposed lid assessment be imposed. If the city wants to build a park and the street is proposed, send it to the taxpayers for a vote. All properties owners will bear the cost. We respectfully thank you for giving us the time to express our thoughts. We know it's not an easy task.
Anything else, Ms. Jordan? No. All right, thank you very much. Sorry to hear of Ms. Campbell's illness. I don't believe we had any, just the one exhibit that's already been admitted.
Yeah. Okay. Thank you.
Thank you. All right, we return to the record for the continued Waterfront LID assessment hearing from case number CWF 300329. May I ask who I have present?
Joe Stewart.
And are you the objector for 0329?
Yes.
Okay. And who do I have on the line?
This is Jan Gruen. I am counsel for owner, and I will be voicing my objections today.
Please spell your last name.
Gruen.
All right, Ms. Gruen, I've received, looks like a missive from you dated February 11, 2020, concerning a request for continuance, which there was an email request for continuance sent Friday, February 7, 2020 at 4:30 or 4:23.
That is correct.
Did you have additional statements you wanted for the record on that?
You know, I have to indicate to you that we're not familiar with this process, and we're attending from California. I am putting these comments on the record because my client has not had sufficient time to retain local counsel They've not had sufficient time to obtain the documents that were relied upon in support of the final assessment, nor have they been able to hire an appraiser who would need to review and critically assess the actual assessment. I've looked at this for the last approximately 1 week. That's all the notice we've had. We've not been able to obtain any of the documentation that we would need in order to understand more fully. I feel compelled to state for the record that the process is violating my client's due rights and rights to fundamental fairness. The rules seem to be selectively applied. I noticed that we can have a hearing continued for good cause shown, and we believe we've met that and then some in terms of a burden under the circumstances. My client is a nonprofit. Its tenant is a 5013 doing critical research on behalf of children in the city of Seattle for Children's Hospital. In reviewing the overall assessment, I note that a number of the entities and individuals have not been allocated an actual assessment. Those all appear to us to be nonprofits in one form or another. We believe that we should not be given an assessment of any kind. There's literally no benefit whatsoever to this project as it relates to our client. It's over almost a mile from the waterfront.
Okay,
It's a
Mr.
two-story-
Let's stay focused on the request for continuance first. You're starting
Okay.
to head into your subject matter argument, which I'll provide you time for, but let me address the continuance first. Is there anything else you wanted to provide for the record for that?
Only that we can only gain access to the records that the tax assessors relied upon by virtue of a public records request. That the actual rules provide 5 days or more for the city to even respond with when we may be able to get those documents. The shortened time and a demand for money, coupled with an inability to have counsel, coupled with an inability to assess what the numbers are here, I think mandates a continuance of this matter. At a minimum, as I understand it, you are able to extend the record and allow for additional evidence to be submitted. But to me, a motion for a continuance ought to be granted in this situation.
Anything further?
No.
Anything from the city?
Our position is that proper notice was given pursuant to the law, and that notice was well in advance of a week ago. So I'm not sure exactly what the reference to a week is referring to, but our position is that advance notice was provided and the documents that are underlying the city's experts report have since been made public, and they've been posted online for some time now.
Thank you. So I'll proceed with this, and I can ask if you, since I know you're not here, Mr. Green, it's a little hard to read you for the room, but let me try to wade through what you've presented here in writing and then what I've heard today. I think there is some confusion about this process, clearly. And I am recognizing that you're just being brought in at a very late date by your client. The official notice for this hearing was sent out December 30th, and the hearing was set to begin February 4th. Your client filed a timely objection on February 3rd, along with approximately 400 other objectors. And on that first date of hearing, the opportunity was provided to begin presenting objections, and many objectors did, and so the hearing initiated on that date. So the hearing isn't starting today, it started on the 4th. Your client on the 4th was given an opportunity to have more time to present than was available on that date. The first day or 2 day of the hearing, there were many people who wanted to object for maybe 5 or 10 minutes. They were pro se. And there were others who said, we need more time than that. They were given an opportunity to sign up for a continued hearing date specific to their case, and your client requested that and was given the time they requested, and that's how this date was set. And so, recognizing you were just retained, the opportunity to have retained counsel to access the records initiated back in December, or more reasonably, let's say the first week of January after that notice was received. There are hundreds of objectors who have either handled this on their own and or retained counsel and or appraisers. And so I recognize that you wouldn't know that because you're just being brought in, but that is something that your client was aware of. And no disrespect to counsel, your client did sit on their rights to retain counsel and bring them in a timely manner. At this time, there are a small handful of individuals still trying to get their cases together and confused about the process that have a requested time for testimony. And at this point, given the extreme opportunity, frankly, that we're giving in this hearing to give objectors time to testify, we have times scheduled through the end of April at this point. The hearing examiner is not adding any additional time for oral testimony. There's been an expansive opportunity for that. However, noting that you're just coming on board, that you do believe you have a case, we do want objectors to have an opportunity to present their case at least to the best of their ability, even if they don't understand the process entirely. I certainly would be willing to leave the record open for you to submit materials via declaration or whatever materials you choose to support your case with. I just noticed today, I noted today for the record that declarations are an admissible form in this hearing, and was speaking to the parties present at that time. So that would be a means for you to, if you choose to take advantage, to do that. If we're going to do that, I will not do it and just leave it open, because this is not an opportunity I'm providing to everybody and their case numbers. Once they conclude, I want them concluded so that this isn't just a ongoing paper mill for individuals to file. So what I will need for purposes of case number 329 is a firm date when you believe you would be able to submit materials. Is that something you can provide me today, or do you need time to think about it?
Well, I have been in contact with local counsel, and my understanding is that they've been given until mid-April as reserved further hearing dates, and also they have time in March. To me, it seems as though we may very well be retaining them, and I would like the opportunity to at least fall within the same category in terms of timing.
Right. So that actually presents you another opportunity, Ms. Gruen. If you are retaining local counsel, there are two representatives, or two or three, I should say. There was a gentleman from Spokane who's going to go in a couple weeks. There has been time allocated to these various counsel. One has 29 clients, another one has 5 or 6. Some of them are acquiring new clients still. What I'm asking them to do is to continue with their case within the time that they've been allotted. We have, and the reason for that is I have one representative who he was given about 3 days. He had about a dozen clients, and he could do it within that. So we're expecting about 2 hours or so oral testimony. That doesn't preclude submitting other items to the record. Some of the others were actually given a little bit more time. There's not a set science to how much time a party needs to present their objection. But in the hearing examiner's opinion, ample time has been set aside to add another objector in their presentation, because there is a lot of overlap. And so I wouldn't preclude you. There's no preclusion from those counsel to add essentially this case number to their list within the time they're allotted. That's one way to proceed, or I can leave the record open for you to proceed how you want. But if you're going to proceed with counsel and still do oral testimony, then I won't leave the record open on this case. I'll assume that we're going to get a notice of appearance from local counsel, and that they'll be lumping it into their set of cases to be presented on the times that they've been allotted.
I would request actually that both things take place. I have not got a firm commitment yet on retaining local counsel, and I don't want to be precluded from the opportunity to add to the record in the event that either local counsel declines or there's a conflict. or
Right.
for some reason or another we're not able.
Understood, and I wouldn't want that to tie your hands today either. Do you have a sense of how long it will take you to retain or work that out with local counsel?
I think it would take approximately 2 weeks. The issue here is that this particular assessment. I mean, maybe the thing to do is to go through my other arguments, but I do want to leave the record open for the time being. Is there have to be some sort of a hard and fast closure date? If so, I would request that it be left open through the end of April.
There will need to be a, as you put it, hard and fast closure date. But what I'm trying to do is work with you in the situation where you have, obviously today, not full answers on what's going to work best for you and your client.
Right.
If you have a situation, I mean, if you need 2 weeks to work out with local counsel whether they're going to take your case or not, that's fine. But if they're not going to take your case, then yes, I do need a hard date when you're going to submit materials so that that's not just left open. However, if you are retaining local counsel, I also don't want an open door for this case for things to be coming in from some other source except local counsel. I'd like a single representative that things are coming through. If they need that time at the end of the oral presentation to submit materials, they can address that at that time. So I'd like to tighten this up enough that you have time to work things out with local counsel, but at the same time we have some definitive date if you don't end up doing that you'd be submitting things outside the record.
So I guess against that backdrop, I would request that we have 2 weeks from today's date within which to determine whether we'll be retaining local counsel, and that the record will be left open through that time and until April 30th, if we choose not to retain local counsel. So in other words, we'll either fall in with the deadlines of local counsel, or we will be extended out to April 30th of this year to submit documentation.
Okay, I appreciate your efficiency trying to have them both addressed at the same time. We have today is February 11th. It's my understanding that counsel for this matter 329 will determine whether local representation will be adequate. I would ask that you provide, have that completed by notice of appearance by February 25th. If for some reason more time is needed, you can submit that in writing. And if you do not or are not able to secure local representation, and again, you'll need to, if local representation is secured, you'll need a notice of appearance. I'll still need something in the record to just tie this up from you that confirms we are not getting local representation, so I know which direction you're going with the file still being open for you. Okay, so give me some type of notice by February 25th. As to
Okay, and may I do that by email?
Yes, you can email that to my legal assistant, Mr. Galen Edlin Cho, who you've had some correspondence with.
Yes, I have.
All right, now let's turn to the open record. Right now, today, the city I indicated the city would have until, they're going to start their presentation, assuming we stick with this schedule, and I think I haven't heard otherwise, so this is where we're likely to go with the city presentation, was the 27th and 28th of April with some other dates left for cross. So the city's going to need an opportunity to respond to what you submit. So I need to take more time than the full month. I need you to have something in earlier than the full month of April in order to have them have an opportunity. But obviously I can give you much more time than needing to argue today. In order to give the city adequate time to respond, they have obviously quite a load of objectors to respond to. City, I don't know how you're managing your case and preparing with your expert.
Sure. I would say that if we could have the materials by like Monday, April 13th, that would be sufficient time for us to review anything.
That's about what I was thinking.
Okay.
So if you can get it a
That-
couple weeks before.
Sure.
All right.
Thank you.
So, Ms. Gruen, let's set a deadline of April 13th now, again, if you do not go with local counsel, all right? So
Okay.
if on the if on February 25th, we hear from you that we don't have the opportunity to go through local counsel, we'd like the record kept open for our case, 329, we will do that, and you can submit what you intend to, again, by declaration or other documentation, through April 13th. The record will be left open for this case number only, and I emphasize that not just for present counsel, but for those who are following this and paying attention to the record. This is a limited opportunity to leave the record open for this case number only. Any other party who is an objector needing the case record left open needs to have that arranged by with the hearing examiner's office during their own presentation time, and it will not be accepted by in writing. I think that addresses everything today. I'm not going to make you put anything on today because you're going to get adequate time to do that later, or and we're really at the end of the time that we had allocated for this matter as well. Is there anything else we need to address to make sure that you have a clear path forward for your matter, Ms. Gruen?
No, I think that does it. I guess the question to me is, at the end of this, you will be approving these assessments, and then the next step would be the filing of a lawsuit if that was deemed appropriate. Is that correct?
No. The hearing examiner will, at the end of the hearing, which, as you hear today, has continuance dates through, started on the February 4th and is continuing through the end of April, will then draft a recommendation to the City Council. And the City Council makes the final decision based on their recommendation. The recommendation is ranging. It can be anything from reverse the whole thing to modifying specific assessments to simply support the whole thing, somewhere in that range. And that's a recommendation. There will be information in the recommendation on how to appeal that. The City of Seattle does allow recommendations from the hearing examiner to be appealed if it's a recommendation to the council. And information on that would be included in the recommendation, and that's the process we have. So, does that answer your question?
I guess yes, it does. Under those circumstances, and in light of the fact that you will be making a recommendation to the City Council at the end of this hearing, I would like an opportunity to make just a few statements about why there should be no assessment here.
You want to do that now? Is that what you're asking?
Well, I mean, I don't have the benefit. I mean, if you're going to be making a recommendation now,
I'm not. No. I'm not making my recommendation until at the end of the hearing. I'm taking all of the evidence in from all of the objectors for the next 2.5 months. Then the city, and it'll be a single written recommendation. So I'm not making any type of decision today. I mean, that's what we've preserved here, really, with your opportunity to appear through local counsel or submitting more materials, is you still get a chance to put your case on. Nothing's foregone with that.
Okay, I appreciate that.
All right. Anything else?
Yes.
The city?
No.
Anything from you?
Thank you very much.
No.
And we're continuing the Waterfront LID assessment hearing, February 11th. Be case number 63. Good afternoon. Please state your name for the record.
My name is Ted Tanasi. My wife is Priscilla Tanasi.
And can you
we are
spell
the-
your name, please?
Yeah, sure. Tanasi is Tanase.
Thank you.
Thank you. And we are the owners.
And do you swear or affirm?
Sorry.
Do you swear or affirm the testimony you provide in today's hearing will be the truth?
Yes.
Okay, please proceed with your presentation.
Thank you. We're the owners of Unit 2403 at 1521 Second Avenue. And we've been the owners there since 2013. And I wanted to tell you a little bit first of just my background, because it's going to lead into this presentation. So I've been in management in the aerospace industry, CEO of a lumber and building material company, and CEO of a company in healthcare. And as the CEO of these companies, many times I've gone and asked for money, and many times I've been asked for money. So the way I looked at this is the way I would have if I was still the CEO of these companies, which I'm no longer because I'm now retired. So I take a look at investments, whether I'm making the investment or if I'm deciding to make and to ask for an investment in terms of return on investment. And for the investor, which is me or us, Priscilla and I, in this particular case, I look at the return on investment. So as an example, if some company has come to me and said, I want you, Priscilla and Ted, I want you to invest $100,000 in my company, and we're going to build a house. And this particular house will have shake roof, it'll have vinyl windows, it'll have hardwood flooring, it'll have Kohler plumbing items. And that's what I want you to invest in our company, because we're going to build this house, and then we're going to sell this house, and you will make 2.7% from this, and I'll guarantee it'll be within 3 years. So for me as an investor, I've been told $100,000 is my investment. That's fixed. So for me, I need to know, how comfortable am I with the 2.5%? How sure am I that I will get that? And with that will determine the return on investment for me. But as I was mentioning to you, I've also been on the other side where I've gone out and asked for money. And in this particular case, I also think of return on investment. Because I say in this case, if I know my return, then I have to really think about the investment. So on the face of things, if you say on this lid procedure, this lid process, I'm going to impose a tax and the tax will pay for my entire investment, then my investment is zero, and the return on investment will be, if I make any money at all on this, it'll be infinite. So on the face of things, this type of a return on investment sounds like very good for the company that's asking for it or the city. What I'm going to be showing is what I really feel is the return and what I really feel the investment is for the city. And at the end, I'm going to be asking for our unit to have the assessment be zero. So that will be my request. I'm in 1521, and so a lot of the things that I'm saying pertains to 1521, but I don't think I can speak for them here, so I'm speaking for the two of us. So being an engineer, when I take a look at some things, I take a look at the mathematics or statistics, and I take a look at things like sample size. So in this particular case, I'm looking at the estimated value increase or perhaps even decrease from the lid. And one of the ways you take a look at this is through sample size. There is a correlation between sample size and the confidence of that or the margin of error. So the smaller the sample size, the less confidence that I would have and the higher margin of error. In mathematical statistics, you take a look at 1, 2, and 3 distributions off of a curve. And if you're one distribution, you're 67% sure, you're 67% confidence of that value. If you go 2, it's 95%. And if you go 3, it's 99%. Many times people say, I want to be at 2 standard deviations, or I want to be at 95% confidence of this value. And so just from a math point of view, when I take a look at the 2.7% that the city is talking to us about, I know that from math, I have to have a sample size of 385 parks or neighborhoods. Or looking at it the other way, I think what I saw was roughly 5 park neighborhoods to determine the 2.7%. With 5 parks or neighborhoods, I am, or the math says, that anybody would be 95% confident that that value could increase or it could actually decrease. So there could be a decrease in the value of our condo. There's another part of estimating value increase or decrease, and that's relevancy. And having been in the aerospace industry and with a lot of the issues about the 737 MAX going on right now, if you said these two are airplanes, you'd be absolutely right. You could say these are two airplanes. If you say that the performance of the jet plane is the same, the 737 MAX is the same as the Cessna 173, you'd be wrong. So relevancy is a huge part of determining whether or not you have confidence that there will be an increase or decrease in value. So Mayor Durkin has said that the lid is a park for all. And in one of her talks, she talked about we should think about Stanley Park. So what I've shown is Stanley Park in this picture, and the little square piece that says lid is roughly the size of the lid as compared to Stanley Park. So the Park for All and Stanley Park are both parks, but like the 737 and the Cessna 130, if you say they're both parks, that's true, but in terms of relevancy, it really isn't, because the lid is roughly 36 acres, the Overlook Walk is roughly 1 acre, the Pier 58 is roughly 1 acre. So in terms of sample size and in terms of relevancy, I, as the CEO of the company who's been asked to invest, I would say, you know, I don't have any confidence yet that I'll get any return from this at all. In fact, it might be a decrease in value. So another piece is the special benefits. And I need to say that I've really had no time, and I haven't received a study of a city's special benefit study. I just haven't gotten that. So my no special benefit slides from here on are based on my review without that study. So, and I was going to give this talk on February 4th at that point where I said the hearing should be postponed until I've had enough time to study, but I think you ruled on that to say we have to get past that. I didn't want to change my slides though. So there was another, Marshall Foster, I believe, who said, let's take a look at the Embarcadero, because it's a park to park, the Embarcadero to the Lid Park, Park for All. And interestingly, the Embarcadero has been studied. And a quote from the study, while the project is considered to have completely revitalized the waterfront area, there are no special benefits associated with the project beyond a 1 or 2 block radius east of the expressway, Embarcadero. Our home is beyond the 1 and 2 blocks. So based on that study, there's no special benefit for us. The Parks Council in New York City did some studies, and they said that congestion, street parking, litter, vandalism actually result in a decrease in value of the surrounding properties. I believe it was a city had HR&A, I forget who that is exactly, but HR&A did a study and said, with this Park for All, there will be an additional 1.5 million people in the area. 1.5 million people, it will add to congestion. The 1.5 million people will produce, according to the study, $65 million for businesses. That's wonderful. I have no issue with that at all. But it'll be a decrease in value to the homeowners. We're all unfortunately familiar with 3rd and Pine, which is about a block away from us. There was also a picture we taken just the other day of a tent right outside our front door. And that same Parks Council in New York said not only congestion, but they said litter and vandalism also result in a decrease in value to the surrounding properties. The lid budget is $347 million. The lid assessment, including financing, I believe, which is what we're contributing to, or being asked to contribute to, is $176 million. Donations, and I'm not sure if that's the correct name exactly, but basically, we're looking for donations of $102 million. So it leaves a shortage of $69 million. And I put a plus there because things like overrun possibilities, real costs, because I think the budget was first made up many years ago with a very small increase, not having completed the environmental impact work, these could add to the $69 million. So again, I'm the CEO of the company who's been asked to invest, and I'm looking at this, and I say, well, wait a minute, how much of an issue could this be? And I'm saying it could go up as high as maybe $690 million. I can also look at this as the CEO of the company going out asking for the money. And earlier, you may remember I said, if I get all the money from taxes, my investment is zero. If I can get $65 million in additional business taxes from that, I have some revenue. So the return on my investment is infinite. I have no cost. So from the company asking for the money, I also have to look at what's the variable here. The variable is the I, the investment. Am I sure that I'm going to collect all the money that I need from taxes so that my return on investment is excellent? So now as I look at it as the company who's asking for the money, I'm saying, wow, I'm starting out with a $69 million hole. So I know I have to find another $69 million. That's assuming the donations come in. I'll just assume they will. But could it be as high as $690 million? The Seattle Times in April of 2018 said, and quote, bike lanes that voters were told would cost about $860,000 per mile, we're actually clocking in at an eye-watering $12 million per mile. That's 14 times overrun. Some of those dollar amounts estimated for what projects would cost were clearly insufficient even at the time. So I think again about the budget that was first put together, I don't remember, 5, 10 years ago. Do we know that that budget is correct even at this time? I thought I might be talking on February 4th. So I said 2 days ago, but this was actually February 2nd. The Seattle Times ran another article that said, quote, the initial contract for the downtown streetcar line totaled $1.85 million. Today, the cost has grown to $14.3 million, 7.7 times the overrun so far. And the line has yet to be built, and the contract is among several now under scrutiny by federal investigators. So it's clear to me that overruns are going to happen. The overruns will result in reduced funds for crime, homelessness, vandalism, all resulting in a decrease in value to our home. I want to talk a little bit about special benefits and general benefits. And the picture that you see is pre-lid looking down the street. And the picture to the right is post-lid. And primarily, and I'm oversimplifying a little bit, but primarily just on the street views on all the streets, what you'll see is some more trees, maybe some more shrubs. You can't see it per se, but it's concrete with knobs on the walk rather than smooth concrete. So it's trees, shrubs, concrete. Those to me are general benefits. I see no special benefit from this whatsoever to have more trees than less, with some people even saying if you put in that many trees, you're going to kill the trees because it's overcrowded. So that, what I don't show here though is the Overlook Walk in Pier 58. One of the things that I read and found out was that the SEPA and again, sorry, I forget what this stands for, but the environmental work was not complete. And I really think that the lid should be halted until it is complete. Some of the things that I have found, CH2M Hill and others have an environmental rule of thumb for ground projects, not water projects, but for ground projects. And just as a rule of thumb, they say you should think about 4% times the base construction cost, or 4% times the 347 million means that in order to comply with SEPA, it'll cost an additional $13.8 million. That adds to the 69 million. They also go on to say that environmental issues or costs increase when something is over the water. They didn't have a value, but they said it's greater than the 4%. So Pier 58 is scheduled to have 49,000 square feet built over the water. So again, from my point of view, I could say that the environmental issues will create more than a $13.8 million issue. That adds to that investment. A lot of people in the construction area that I've talked with, in fact, 100%, but I only talked about 5 or 6, said that the environmental impact study results in changed plans. Because they'll do a study, they'll see something that says, uh-oh, this is really way beyond what we can possibly handle, so they'll change the plan. But in this particular case, the lid projects can't be changed. So let me jump back again to the original ROI where I said I was asked by this company to put in some money, and what they're going to deliver was a house with shake roofs, with vinyl sliding windows, hardwood floor, etc. If the lid goes through, the company has to produce that. They don't have a choice to say, you know what, I think we won't do these things any longer. So as the CEO of the company asking for the money, I'm saying to my staff, you're saying that I can't make any changes, even including something that comes up under the environmental? And they're saying that's correct. Whoa. The SEPA issue, from my understanding, is one of the 3 items that's, there's a trial coming up in May. Another part of that trial is the taxation without representation, where the city council members voted for the lid tax in districts that they don't represent. And then finally, some disqualification. There were 7 city council members who spoke to the mayor's office and others during the quiet period when no discussion was allowed. And I think the remedy for that is that the 7 are disqualified from voting. But this is all part of a trial. So I was thinking maybe you might want to wait until May of 2020 to see what happens at the trial, because it might stop everything anyway. This quiet period is a personal issue with me, because I had called the council to talk to them about, you know, I think I got a better way to finance this that would be better for not only me, but for the city as well. And I was told I can't talk to us because it's a quiet period. So I didn't have a chance to talk to the council at that point. But then I hear that 7 council members went out and talked to the mayor's office and others. So it's just, I can tell you, it's a personal, I won't say what else, but I'm not happy with that at all. But what my purpose was that I was going to propose an alternate or more appropriate funding. So let me say again, if I'm the CEO of the company and one of my staff members comes to me and says, I want to build this house the way I built it, and I'm going to tax people, I'm going to collect them, and I can get an investment for this, but we have to build this house exactly the way it is. We can't change it, and we have to get it done in 1 year because that's part of the deal. If I have another staff member who comes up to me and says, you know what, we can get the project done just the way the first person said, and I can do it in a way where if I need to change a plan because of SEPA, or if I run into some issue, I can change the plan slightly, I can give you the company, I can give you the flexibility to make those changes. But I can't do it if I collect through this lid tax. So I'm going to tell you now what I would do if I was the CEO and I wanted that project to go ahead. I would take a look at getting some funding through naming rights. T-Mobile paid $87.5 million to get the Mariners Park turned into T-Mobile Park. I think there's a good chance that you could get Amazon Park, Boeing Park, Google Park, Toyota Park, or whatever, and you should be able to get $87.5 million. Who wouldn't want to have their name associated with a park for all that's supposed to be a fantastic park? And in fact, if they wouldn't do it, I think that tells you something else, which means nobody out there feels this park is, they want their name attached to it. So I think that you can pick up $87 million from naming rights. I read there was 14,000 visitors per day from cruise ships during the summer months. If you take the 14,000 per day times 30 days per month times 4 months, and you charge just for those times $10 per passenger landing fees, you'd make $16.8 million per year. And over 20 years, that's about the budget, the entire budget from that. This one is a little bit tongue-in-cheek, but I've got to say, after someone was murdered outside of our building about a block away, a few days later, Chief Best said, you know what, we've hired 180 new officers, we're still 20 people short, but you know what, we're doing a great job. Major crime is down with that few less, with 20 less police officers. So I say, great, you don't need them. 20 times 86,000, which is the fully loaded officer cost, I believe, means $1.7 million a year. So you can pick up $1.7 million in over the 20 years that the city has talked about. I mean, it's whatever that is, 30, 24 million, or whatever, 17 times 2 times 20. New building fees. Right now, existing buildings are being hit for the lid tax, but new buildings don't have to pay anything. At last count that I saw, there's 213 buildings that are in the pre-development to under construction stage in downtown Seattle, with roughly 15% happening to be in the lid area. So if you have 213 buildings times 15%, and if a building is worth 200 million, you multiply that by the 2.7% that we're saying are the value of our condo go up, and the 40% we're charging, comes out $69 million, which just coincidentally is the amount that the city is currently saying we're short. Commercial parking fees. If you increase the commercial parking fees by 3%, you're currently collecting $45 million. You would collect $1.5 million per year. And again, over the 20 years, that's $30 million. Sunday parking fees. I don't know that if there's Monday through Saturday fees, if you add a seventh day, you might say you could pick up 1/6 more in fees. I don't know, but it just seemed like Sunday fees may not be as much as the other days. So I've said if you did Sunday parking fees, you could get 1/10, not 1/6, but 1/10 of the commercial parking fees. So you could pick up $4.5 million per year. Again, over the 20 years, whatever that comes out, 9 or 10 million. There's also new businesses that are going to be happening in the lid area. I don't know, I couldn't find anything about what businesses could be, but you could pick up something there. But my point here is that you can, every one of these, or all of them certainly put together, you can come up with alternate funding that'll do the lid project without the lid tax. Having said all that, there was one thing I wanted to mention also, which was that we feel our assessment is too high. So we went and had And I have this for, what do you call, evidence to turn in. So I'll turn this in a second. But we had Compass Washington do a comparative market analysis on January 29th. And the analysis was based on actual sales comps as contrasted to the lid estimated value. And what it showed was that the lid estimated value for Priscilla and me was high by $383,000. And the $383,000 times the 2.7 times the 40% is a little over $4,000. So if you forget everything else I've said, I think that there should be a reduction in the assessment of $4,136.40. So in summary, when I take a look at the return on investment for us as the investors, I can conclude that the return is actually zero or negative. And there's probably, you can't do this, but if I'm being forced to pay this, it seems like if somehow my value based on this lid, if we could figure it out, is negative, then the city should give us money back. But I don't think you can do that, but it seems like you should be able to. The ROI for Seattle as the city, the group that's asking for the money, you do get additional revenues and the tax benefits from that. This one study said $65 million more. So you do get a return. But your investment is already $69 million short. And I think we can certainly see SEPA, overrun history, et cetera. It could be as high as $690 million. And so if I'm the company, if I'm the city, I would say, I can't take 69, I can't take $690 million from other funds when you've got homeless, vandalism, you've got other issues. I can't take $690 million and put it into this project and finish it the way I said it was going to be done, because I have no choice. I have to finish it the way I said it. So from a math or statistics point of view, and I took a look at it, the lid could result in an increase or a decrease in the value of our home. From the Embarcadero study, since our home is outside of any of the lid positive effects, our assessment should be zero. From the Parks Council study in New York, congestion, vandalism, litter decreases the value of our home. And since funds, because of the $69 to $690 million overruns, are going to take funds from vandalism, litter, et cetera, I think there will be a decrease to the value of our home, and so our assessment should be zero. The overruns, see if it's not completed. I think, I would guess that anybody or everybody would say that after the city has completed SEPA, there will be additional costs, which will, again, lead to additional or less funds for police or vandalism protection or whatever. And so based on that, again, there's a decrease to the value of our home. So I think our assessment should be zero. The trial is in May. We've talked about that a little bit. So in terms of financing, I think the best for us as well as for the city is to cancel the lid tax. Continue with the lid project, because I can tell you, I, for one, I like the fact that we could have 1.5 million more visitors. I'm a business person. I like the fact that it's going to be helpful for visitors. So I'm not against the project. I just think that there's a much better way of doing it that would be protective of us as well as the city. And then lastly, if everything else doesn't work well, I'm requesting that our assessment be reduced by $4,136.40. And that concludes my presentation.
Thank you. Did you have anything you were introducing?
This is a hard copy of the presentation,
Okay, that'll be marked as Exhibit 1 for case number 63.
and this is the comparative market analysis that was done.
That'll be marked as Exhibit 2. Both exhibits will be admitted. Anything further?
Nothing further.
Okay.
I have just a few follow-up
Oh,
questions.
sure.
Cross-examination?
Oh, okay.
Mr. Tanasi, you started with some of your background as a CEO. You are not a certified real estate appraiser, are you?
I'm not. That's
And
the reason I went to Compass to get the appraisal.
thank you. And you have not received any formal training in appraising or valuing real estate?
I've not.
Okay, thank you.
Okay.
Thank you. We adjourn. We will return for the continued hearing again tomorrow at 9 a.m. with case number 89. Thank you.